circumstances that special arrangements ought to have been done to ensure that they were able to exercise their rights under Article 1 and Article 38 of the Constitution. Now, why have we chosen the figure 700? The figure 700, as you will see from the affidavit, has been chosen for the simple reason that there should be no contentions about it. These figures, these are elections officials. The IBC chairman is quoted in the newspaper report that is attached to that affidavit, in fact confirming that indeed all this number of peoples will be engaged during the election day. Their engagement during the elections day follows up of necessity and in the nature of their duty that starts at earlier than 6 a.m. and ends long past the counting period, that those are the people envisaged under Regulation 90, that special arrangements to ensure that they vote would be made. It is not denied, in the face of how these complaints being made, that those arrangements, in fact, were not made by the Commission. Now, it is important to point out these regulations were made in the year 2012. Of course, it is interesting to know, faced by these complaints, how did Chebukati answer them? He answered them in his affidavit by first of all saying, prisoners were allowed to vote under Regulations 90. He says diaspora Kenyans were allowed to vote under Regulation 90. And he also says very old people and sick people would be first on queue, and so such instructions were issued to ensure that those kind of people would vote first with a little bit more convenience than others. But, Your Lordships, it is important to note that when it comes, for example, that prisoners voted, prisoners have been voting in Kenya in the presidential elections, not so much because IEBC has been complying with the law, but because I believe it was Judge Lenaola, when he was at the High Court, made an order first that prisoners to vote in the presidential elections, and number two, in the referendum. And that was done. Even the reasons why diaspora voters vote in Kenya is again because of another subsequent court decision. So that where we stand today, for purposes of Regulation 90, IEBC cannot give a single instance that in support of ensuring that as many Kenyans as possible will vote for the presidents of Kenya and exercise their rights to franchise has ever done anything. There is no evidence of that. Now, during the preparation of this petition and afterwards, for purposes of these kinds of violations of the right to franchise, it is a very serious thing across the world, because as many of us are entitled, and that is why even this right was given to prisoners, to ensure that we vote. You find in very many other countries where elections have been nullified because of the issue of franchise, but you do not have a single instance, at least to the best of my knowledge, that this has ever happened in Kenya. And this could probably explain why, even after the Constitution is clear on this issue, that facilitations be made to ensure as many people as possible, and those in special circumstances, those arrangements have never been done by IEBC. It is my submissions that, given the results that were declared on the 15th of August this year, voting by up to 700,000 voters, even if that was adjusted, how many of them could have been registered and how many of them could actually have voted to the actual averages, you would still have arrived at a very big figure of more than 300,000. That directly, and on account of non-compliance with an express provision of the law, were unable to vote. Did the failure to make that accommodation, those arrangements, to ensure those people voted affect the results of the elections? Undeniably. If those people had voted, it is our submissions that the results of the elections could have been affected. And my Lord, it's in my submissions that unless and until this honorable court take up that issue as a serious issues of violations of constitutional law, then Regulation 90 could as well be an empty piece of legislation. And therefore, part of the enforcement of ensuring that the universality, that the free franchise and universality of it is respected would be to ensure that a very serious elections was violated on its account. And it is on that reason that when we read our submissions, we are urging the court to do exactly that. Issue number 2 has got everything to do with the fact that the duty of accountability and verification, as we had said, was violated at various stages. It is my submissions that there are at least 4 stages in which this happened. Number 1, stage 1 ordinarily occurs the stage between 20th, the election period. A gazette notice was issued on 20th of January to signify the commencement of the election period. That period ended on the 8th of August. Then there is stage 2, voting day. Then there is stage 3, which is a 7 days period under the procedure set out under Article 138 of the Constitution. Stage 4, in my submission for purposes of the presidential election, it is the 21 days period under Article 40 of the Constitutions that you are dealing with right now. Now, what are the stages at stage 1? The issues at stage 1, and I will link them up with how they tie to the elections, is the fact that in this particular case, IEBC, according to my clients, was supposed to ensure that they set up to ensure that the outcome would have credibility in the eyes of the electorate. The one single issue that we have pointed out for purposes of that in an election using Kim's kit, it has been recorded, it is our submissions, that on day 1, in their affidavit, they say 6 hours, that at least 6 hours after the conclusions of voting, Kenyans ought to have known what many people voted electronically and using any other complementary system of voting. And my lords, it is my submission that the failure to do that, one cannot be able to speak of a technology that worked if the most important component that a voter ought to know, the right of a voter to know, yes, we voted. If we reach this number, this man is president. If we reach this number, this one is president, or is in the opposition. That number ought to have been given without any dispute. There should be no controversy about it. Yet the fact that you have all these controversies about the register just points out to the issue that on that critical element, there was serious failure of that technology. But it may not necessarily have to be a serious failure of the technology, in the sense that it could well be that the manner in which now you conclude voting, Forms 34A were uploaded, but the actual figures were being named on day 2. This is day 2 after the arrival of all Forms 34A. It is our submissions and my hypothesis that any person, and nowadays there are so many books that you can read anywhere and you can buy anywhere, that says how do you rig elections. If one was set out to rig an election such as this one, then one of the most important variable would be the voters' register. And in this case, it is our submission that the fact that on day 1, 6 hours after the election, we were not told in a controversial manner, and after Kenyans have invested in a technology, that this number of people voted. This opened the system in the subsequent verification process to the kind of abuse that more other able people in that area have spoken about today. But that, on the face of it, appears to be where the opportunity arose. I go to the issue still at stage 1, the issues of the nomination. We have said in our affidavit that for purposes of Article 99 of the Constitution, the presidential candidates were supposed to be subjected to qualifications under Article 99. The manner in which that was done for purposes of presidential election, the second respondent was actually not subjected to it, and at the end of the day, a person with unresolved questions under Chapter 6 is today Deputy-elect of the Republic of Kenya, arising out of the failure of IEBC to enforce the law. The next issue is the publication of a Gazette Notice number 9540 on 8th of August. This Gazette Notice in our submissions was an instrument of illegality. My learned colleague, Mr. Nyambodi, says that IEBC chairman is always inclined to produce Gazette notices even where none is required. I read it differently. If you read Gazette notice as an instruction manual, it makes a lot of sense. In this sense, that in the ordinary scheme of things, and particularly when I was working in the human rights movement, when you deal with a lot of police officers and other people on those junior ranks, this activity will be carried this way. They'll not tell you the Penal Code says this, the Police Act says this. They will tell you the forces standing order, which they are socialized to understand, says this. So this was the forces standing orders. So that for purposes of the day when this verification was being carried out under this, what we are calling stage 2, it was being, and it was published on the eve of the election. There was also the bad faith that on the eve of the elections, you publish such kind of a Gazette notice that runs directly counter to the Constitution. Why would anybody do that in good faith? There was lack of good faith. Because in the Republic of Kenya, during my practice of a couple of years in public law, we are aware this is the kind of stuff that we present in constitutional division and the judicial review courts to confirm whether or not it complies with the constitutions or statute. Therefore, when you publish such a Gazette notice, an instruction manual that would be deployed during the verification exercise, and the following day is a public holiday, you cannot be taken to have been done that with the best of intentions. We got to stage 2, voting day. Voting day, the first violations that we talked about, not everybody entitled to vote under Article 138 in the presidential elections actually voted on account of non-compliance with the law by the IEBC. The second issue for purposes of that day, I've already talked about it, is a voters register. That on the elections day, and we have said 6 hours, you needed to know how many of us voted. The moment that information was not provided, the system and the process was exposed to anything could happen. And actually by the 15th of August, the worst, and all that could go wrong actually went wrong on the 15th of August. And therefore this is why we are saying these violations were not just minor violations. They were violations that indeed went into the heart of what is before this court, the disputed elections. At stage 3 is what we call the procedure under Article 138. Well, my constitutional law mentor, Dr. Gibson Kamau always used to tell me, and I believe most of the people who had the privilege to be his pupils, that the Constitution must be understood in a historical context. And therefore it is important that we understand Article 138 in a historical context. What is this context? This context, my lords, is this, that we do not have an equivalent of Article 138. We do 6 elections. The Constitution has not told you this is a procedure at the parliamentary elections, or the governor, or anybody else. It is only reserved for one position, the president position. The procedure at the presidential elections. And this was to leave no room of doubt that this is how in which the verification process ought to be carried about. My lords, the process after we vote in a presidential elections, I first voted in 1992. And since that year, the first multi-party elections, after voting, of course, in Kenya, they tell you, vote, go home, watch it on television. You will get to know the outcome. How it has always worked is that you are there at home, results are read from constituencies, from everywhere else across the country. It is a ritual that happens every year as far as I can remember, since the year 1992. Now, what is the importance of this ritual? It is important to remember that in the year 2007, this ritual was disrupted by the events that happened at KICC. The disruptions of this ritual led to the post-elections violence, and the rest of it, we are all aware what happened after that. So that it is not a simple ritual. And so that in the year 2010, when the Constitution was written, it provided for a sections and 7 days and a procedure, setting out in no uncertain terms, this is how, after people vote for their president, we are going to process the issues. So that the Constitution, having dealt with that issue against that historical background, you cannot have a situation where subversion through a gazette notice is tried to be effected. That would be treason in every sense of the word. I go to the issue of what's the importance of the ritual. To the winner of an election, this ritual that we saw in this constituency, what you got in my neighborhood, is very important. Because the people, while we are seeing all this being displayed, and remember that during Bomas, the display to show Kenyans that these are the results that were coming in, this is how the figures were adding up, that was disabled at some stage. So that what effectively this meant, that the true purpose of Article 138 ends up being defeated. Defeated in the sense that for the winner goes and declares that I had the most numbers in accordance to Chebukati. And the loser, everybody else says, I do not know how you got those numbers. I actually thought I had more than you had. This is what was tried to be prevented. But it is equally important, the procedure under Article 138 for the loser. Why is it important for the loser? Because the loser, and in this case, the loser is a loser with say, about 6.9 million votes, quite a number of Kenyans. This is a loser on his 5th time seeking the presidency. The last one he says he lost under controversial circumstances. There was everything necessary to ensure that for purposes of these elections, if you are to lose the election, the math must make sense. It must add up. The Kenyans, those people who voted for you, must also see that you did not do very well, because it is clear these people in that other place did not vote for you as you expected. Now, but when you have now a true situation on the 15th, the dramatic events of the 15th of August, where even 27th constituency, my clients are there waiting at home. I was also equally waiting at home. Those results are not announced. Then how do the people who are supposed to be losers understand that they genuinely lost in the elections? That would strip the process of legitimacy. But it is equally important for another reason that Wallace Soyinka talks about in one of his essays. And I believe the essay is published in a book called Climate of Fear. And Wallace Soyinka, in an essay titled The Quest for Human Dignity, says that in war, it is important that those who lose a war should not be stripped of their dignity. And basically what this means is this, that even after losing war, you are not stripped naked, in the sense that you are told you lost half of your country, but you must be left with the other half. That is if you are in the Russia-Ukrainian kind of situation. That is the whole idea, that nobody should lose absolutely. And when the Constitution talks about fairness, about transparency, it is to enable that this is processed in a manner that everybody else would be able to understand and to process the victory or to process the loss if it turns out that it was a loss. Now, we go to the issue number 4. I wish I could say more. I'm just trying to, to watch myself. Stage number 4, the final issue is the Supreme Court issue. We served Chebukati with our affidavit. And I would not say he's arrogant because that may not be a permitted language. But the language that used is one that shows lack of remorse. You will read the affidavit. On the issue of, why didn't you make arrangements for everybody to vote? We were talking about specific people, election officials. Then he says, oh, prisoners voted, diaspora's people voted, and all these other people voted. Now, that was not the issue. I think they are needed, and this is accountability to the Supreme Court. And that is the design of the Constitution. That now that a violation has been committed, what do you have to tell the court about it? You could not even say it was an oversight. The next one, I will recommend to the next chair to ensure it is done. There was no such thing. Then we go to the next issue. In our affidavit, the third petitioner says, I was disturbed about the events of 15th because in the morning of 15th at around 7:30 a.m., I was shown some text that seemed to show the results that now are being announced later. Why was it disturbed? Because at that time, votes were still being counted. People are being told in constituency A, this is what people got. How does Chebukati react to that? Oh, everybody with a good calculator could have downloaded these forms 34A and calculated. Now, Kenya is a country with extremely low digital literacy. To say, and when such a thing that would cause concern, that there was a problem, and you say this information was readily available, leaves a lot to be desired on the part of a public officer. I start with finishing with the issue of legitimacy. It is important that winners should have legitimacy. And it is also important that the losers also should be treated with dignity. When we read the affidavit of Honorable William Ruto, he says, oh, so many people, why are you pretending that you are acting for all Kenyans? So many people agree with my victory. But it is also equally true, so many other Kenyans don't agree with it. And therefore, in a constitutional democracy, as I conclude, it is absolutely important that when you win, and Article 38 says you win it this way, it must be confirmed. Thank you very much.
Thank you very much, Council. We would like to take the submissions by, I think, 4 respondents who are supporting the petition. That is the 4 commissioners. According to the time schedule we allocated yesterday, they were to share the 1 hour. But before Council, you take the podium, we are proposing just a 15 minutes health break. Then we come back because we will hear those submissions. And if there are questions from the bench to all the submissions that have been made, they will be directed to Council. So we'll need about 1.5 hours when we return to finish today's proceedings.
Retire on the word from Justice Lenola, could the court find out what's happening to the question of scrutiny? Because it looks like we still have a crisis.
Yes, we shall. I'm aware.
Oh yeah. Zile tulizodeka mdogo in it. Nashika tumbo vizuri.
Mm-hmm.